Business, Energy and Industrial Strategy Select Committee for our first hearing in our new inquiry on the future of competition policy post-Brexit. And for this scene-setting kick-off session, I'm delighted to welcome John Penrose, of course the member for Weston-super-Mare, but who has written a report for government on the future of competition and consumer policy there in hand, and George Perrett, QC, welcome, who works with the bars and law societies on competition and state aid policy. So good morning to both of you. Just to kick us off, this whole inquiry, as well as the consultation from the BEIS department, is built on the premise that now that the UK has left the European Union, we have opportunities to reform competition and consumer policy in the interests of the British economy and British consumers. So, first of all, John, what are those opportunities?
Well, really quite profound, but there's some sort of equivalent sets of threats that we need to worry about too. So, for example, now that the responsibility for what was previously done by EU competition authorities is now resting back in the UK post-Brexit, we clearly need to upgrade the existing UK competition authorities in order to be able to cope with that extra workload. But it does mean as well that we can take our competition authorities, which isn't just the CMA and the Competition Appeals Tribunal, it's also the economic regulators, for example, which cover a whole swathe of our economy, most of the utilities, so energy, water, transport and so forth. And we can make them work faster, we can make them more pro-competitive, and ultimately the point is that if you have a sort of heavy regulatory burden in order to deliver competition, you're not going to be as efficient or as productive an economy as one which achieves the same things with less red tape, with less cost, and does it faster and more digitally. So there's a big opportunity to sort of upgrade ourselves for competition 2.0, but equally we need to be careful because we're not quite in the top rank at the moment as things stand. And if we just carry on as we are, we won't get back there.
And who's above us in the rankings?
Well, there's some. This isn't just my personal view. There are actually some international rankings, and so if you look at what other competition practitioners say, they tend to put USA, EU, France, Germany, and Australia ahead of us. So we're sort of pretty good. I mean, I don't want to sort of underplay it. We've got a lot to be proud of and a lot to build on, but there are a few people who are sort of marginally ahead of us.
And George Perrett, post-Brexit opportunities.
I think that, opportunities and challenges probably go together. I think John is absolutely right to point out the challenge to the CMA and the other regulators of having to do more work, because they'll be dealing with huge international mergers that previously went to the European Commission. They'll be dealing with huge international cartels that were previously dealt with by the Commission, and they'll have to work out how to coordinate with the Commission on many of those inquiries, and that will raise various issues. So there's going to be a sort of resourcing question. At the same time as it happens, the CMA is also being given a whole lot of new work to do in relation to subsidy control and the Internal Market Bill. So that's another challenge. There's also an issue, I think, about the sort of substantive rules. What exactly are the competition rules? We have very much modelled our competition rules on the EU competition rules, deliberately so. We've tied our boat, as it were, to the big ship of European competition law, and that has got us to where we are. The boat is now untied. We are where we are because of EU competition law, but we've now got to decide whether, as it were, to follow the EU boat or to set off in our own direction on a number of issues. We can sort of talk about the details of that later, but there's as always with these questions of divergence, there's a trade-off between, on the one hand, divergence brings costs because business has got to take advice about two separate regimes, and that means two sets of lawyers' fees instead of one, and two sets of things for businesses to worry about. On the other hand, there are opportunities, particularly as the EU ship itself may, to continue the metaphor, may head off in a direction that isn't quite designed for us because we're no longer formulating where it goes. So we may find we want to head off in a slightly different direction.
And so in terms of divergence, whether it's our divergence or the European Union's divergence, there will be divergence. This debate about us actually ultimately having to stay pretty close to where the European Union is not true?
I think at the moment, the way that the Competition Act has been amended, essentially the default position is probably that we stay with the EU. The courts will certainly look very carefully at new ECJ jurisprudence on competition law issues, and other things being equal may well follow that. But there are certainly areas you could point to where divergence is perhaps more likely. I mean, the sort of obvious area is distribution rules, where the EU always has had a slightly idiosyncratic approach to rules on distribution, largely because it's concerned with internal market issues and avoiding barriers within the internal market. So it looks, for example, very disapprovingly at distribution practices that allocate exclusive territories to particular retailers or dealers, where we don't have those concerns. So we may move in a slightly more liberal direction on that sort of issue as time passes. And there may be other areas as things, it's slightly difficult to predict, as always with these things, where the EU law is going, and so one doesn't quite know whether we will want to go along with it or not.
You just made reference to the courts looking at ECJ jurisprudence. Politically, if that were to continue, that would cause some contention, certainly here in Parliament. Obviously, we inherited the acquis at the point of leaving the EU, but if you could just explain that a little further for us in the future, why would British courts be looking at ECJ jurisprudence?
Well, actually, it's certainly in the field of competition law, it's quite common for courts around the world to look at other courts' jurisprudence, because you're often dealing with very similar issues. You know, is an agreement anti-competitive? Is a particular type of conduct anti-competitive? And any sensible court will look very carefully at what other courts have done. I mean, I've personally recently been involved, as it happens, acting for the European Commission in relation to what are called pay-for-delay cases, agreements between pharmaceutical companies and generics that essentially paid the generics to stay out of the market for a while. Well, the theory of what in the EU system would be called abuse of dominant position is originally developed in the United States, a Supreme Court judgment called Activis. And though the European Court of Justice judgments on the pay-for-delay issue don't actually cite Activis, because the European Court of Justice never does cite any other court, the judges were certainly made aware of it during the hearings. And I think if an English court were now looking at this issue cold, they would look at the US Supreme Court judgment, and they would look at the ECJ judgment, and they might look at judgments in Australia. So it's part of just a process of looking around and seeing what other jurisdictions do. I mean, I think the courts are well aware of the political sensitivities, and are also very well aware that Parliament has told them not to regard EC judgments as binding. And I think if I were as counsel trying to rely on an ECJ judgment, I would do so with a certain amount of tentativeness, being aware of that. But it seems to me entirely, if one sits back and thinks about it, it must be right for our courts to look at what the ECJ has done in relation to comparable problems, just as it looks at what the US Supreme Court or the Australian High Court may have done on the same issues.
Thank you. And lastly for me, for this section, John Penrose, obviously these rules and institutions and frameworks are important for the functioning of a modern economy, but what are the benefits for the public and our constituents in doing this work?
Oh, huge, because a really competitive economy, or a competitive set of high quality set of competition institutions deliver a more competitive economy. And what that means is a whole series of things. It means that ultimately our economy grows faster. We have a long-term productivity problem in the UK economy, much studied, much commented on, and more competition would be one of the major things we could do to iron that out. It could also help with levelling up, because at the moment, if you look at the productivity of the UK economy, London and the South East are world class, and then it gets progressively less competitive and less productive as you go further out into other parts of the UK. So increasing the competitive animal spirits outside London and the South East could be a major part of that. But equally importantly, ultimately, if you've got a faster growing economy, that's ultimately the thing which pays for all the public services that we all care about, and ultimately also underpins the long-term viability of the organisations that give us all our jobs, and stops us being hollowed out by foreign competitors eroding their position and stealing their market share and taking jobs offshore.
Thank you. Mark Pawsey, please.
Yes, if I can follow up on that, John, if I may, because you said a competitive economy grows faster, but the business conditions over the last 18 months have been exceptional as businesses have had to deal with the COVID crisis, where perhaps maybe a coming together, for example, on issues like food distribution might be seen to be better for the country as a whole than having businesses continue to compete with one another. How should those tensions be managed, and what has been the experience over the last 18 months?
Yeah, and I'm sure I wasn't the only person in this room who, when they heard the news about a sort of temporary relaxation or suspension of some of the Competition Act requirements in things like distribution, that will have raised a few eyebrows. But actually, I think that it is justifiable to do that in the very short term when you're faced with a crisis like a pandemic. Because everybody needs to put their shoulder to the wheel, everyone needs to pull together, and it's essential to sort of to get everybody trying to do one thing really fast, really efficiently. That said, if you start to do that in normal times and over the longer term, none of us need to be criminal geniuses to work out that it's the sort of thing that can easily curdle into producers ganging up against consumers. And ultimately, the bit I should have added in response to Darren's earlier question, the Chairman's earlier question, is that if you have a competitive economy, it means lower prices, it means better products for all of us too, and it means that it's being run. There's no point in having competition unless you do it for the benefit of consumers rather than producers or monopolists or anything else.
Was there any evidence of producers ganging up against consumers?
I haven't seen, and I think it's probably a bit early to say if there's anything from during the pandemic, but more broadly, there's always evidence of that sort of thing happening and being in tendency. Otherwise, people like George Peretz would never be in work. Yes, it is always a temptation. Yes, it is always a danger, and yes, it is always happening. The whole point about having good competition authorities is to make sure that you stamp on it and you design it out as much as you can.
Was it right to suspend competition policy?
As a temporary emergency measure, yes, I'm sure we can all live with it, and yes, it was probably necessary. As anything other than a temporary emergency measure, pretty dangerous.
I mean, it's probably worth saying something about what suspend competition policy actually meant. Yes. Because, actually, competition rules, competition law is not stupid. It's recognised that there's all sorts of reasons why businesses need to talk to each other, and that in exceptional circumstances, businesses may need to talk to each other about things that would normally be frowned on. If you've got a shortage of some essential product, it may make sense for the manufacturers of that product to talk to each other to make sure that there are adequate supplies in different parts of the country. Now, normally you'd be horrified at the idea of manufacturers talking to each other about where they were supplying, but in those circumstances it may be fine. Now, just as a matter of general competition law, you can always try and justify any type of agreement if you can show that it's overall beneficial, to simplify a bit. What the government did by suspending the competition rules, effectively what it was doing was providing a safe harbour. What it was saying is, to business, you don't need to worry about where the courts or what the CMA will actually say about whether what you're doing is justified or not. So you don't need to rely on your legal advice, which is inevitably going to have a sort of caveat in it. Your lawyers would say, yes, I think the CMA would probably agree that this was necessary, but I can't be absolutely certain and there's a risk. You replace that uncertainty by saying, here is a safe harbour, provided you stick within the framework of laid down in the rule. You can talk to each other about these things as much as you like, and you do not need to worry about your lawyer's advice, which inevitably will have caveats at the end saying, I can't be absolutely certain the CMA will like this.
John, is there a danger that if during something like a pandemic, these people who wouldn't normally talk to one another start talking to one another, they form relationships, and they might assume that that's the new norm?
Yes, that's always the danger, and that's why it's really important to say temporary emergency not to become the norm for precisely the reason you just described.
Okay, and what about consumer protections? There's some evidence that people who paid deposits to go on holiday didn't get their deposits back. Are there consumer protections adequately in place? And is there more we should be doing to protect consumers who might feel that they've been ripped off, and the businesses have taken advantage of the fact that we've been in the midst of a pandemic?
So there was some good work by the CMA and others to try and make sure that people got their money back from airlines and bits and pieces like that. So that there was genuinely proper redress being provided in real time or pretty close to it. So some good things happened. However, as a broader point, one of the recommendations I made in my report is that the CMA's consumer powers, which are currently a sort of slightly pale imitation of their other powers in antitrust and elsewhere in their work, those need to be upgraded because in general those powers are less effective.
Were they adequate before the pandemic, or was there evidence that they needed beefing up beforehand?
Yeah, exactly. So my recommendations here were based on a much longer run, broader and more fundamental point. And so they did, I think, reasonably well with what they had during the pandemic, but there's a fundamental point that it just needs an upgrade. It needs to be much stronger.
Thank you. Thank you, Chair.
That's right, Garni, please.
Thank you so much, Chair. Mr Penrose, I don't think I'm misquoting you when you commented the CMA powers were inadequate prior to the pandemic. Would you use a stronger word than inadequate when it comes to looking at products that are made available to consumers via social media platforms? It seems to be a huge rise in tech companies, but not a huge rise in understanding or authority of the CMA.
Yes, absolutely. So it's worth remembering that our last Competition Act in this country was, I think it's 1997. I mean, there's been a few...
Important to note that, 1997.
No, 1998. I'm corrected by my learned friend on my right. But so that's before the internet got going. It's before Uber. It's before Google. It's before Facebook. Any of these things. And so we're working with an analog system in an increasingly digital world. So there is. And parts of it still work fine because some of the principles, which things which were wrong before in the analog economy, are still wrong in a slightly different format in the digital economy. But it's clear that we've got to update the thing. It's clear that we've got to sort of catch up. And so there is some good work. There's some good work already underway. For example, the CMA is setting up the Digital Markets Unit, which I argue needs to be renamed. But it's a step in the right direction. But that won't have teeth until we've got a new piece of primary legislation. You don't have to use primary legislation for everything. There's a whole series of things we can do with changing memorandums of understanding and secondary legislation, but we're going to have an upgrade and fast.
Thank you. Mr Pertz, I'll come to you because you're a man of words. You probably come up with a more powerful word than inadequate. But if we're looking at digital services, you've got consumers paying attention and their data being moved on. And at the moment, legislation dates back to 1997. Give us some of your powerful words on this.
Yeah, I suppose I tend to separate issues into consumer issues and competition law issues. Looking at it, and I'm a competition lawyer rather than a consumer lawyer, so I'll say a bit more about sort of consumer law aspects. You can, to a large extent, use the tools that we've got to deal with a lot of digital market issues. You've got, for example, the merger control regime can deal with acquisitions by the big digital players. There's been some concern that some acquisitions that should have been picked up weren't picked up, but that's not really, it's more a sort of fault of decision making probably rather than the fault of
give us an example
the regime. Well, the well-known one is Facebook, Instagram, which there seems to be a consensus now should have been picked up and wasn't. But it could have been. There's no jurisdictional problem under the old regime. Indeed, it was looked at. It was just a lot of people think the decision was wrong. And there are evident difficulties always in a fast-moving market in looking at the position now and trying to predict what it will look like in 4 or 5 years' time. And sometimes, no matter how perfect your regime, decision makers are going to get it wrong. And it wasn't, to be fair, just the UK regime that got it wrong. It was looked at across the world. And if you're thinking about the way in which big digital companies use or misuse their monopoly position, you've got abusive dominance rules. But there is certainly a strong case for specific digital market regulation. The BEIS has its consultation paper on that. Once the proposed regime is beginning to take shape, it will require legislation because it's going to give a whole lot of new powers to the CMA to set out to apply the law, to You've got to define who you're going to catch, and unless you're simply going to write Google, Amazon, Facebook, Apple into the legislation, you've got to think of some form of test that catches them and perhaps other people you want to catch, but doesn't catch people you don't want to catch. So you've got that design issue. You've then got to give the CMA powers to set out a code. Mm-hmm. And I think also, general point, you as parliamentarians need to think to what extent you're happy for very, very important regulatory decisions, effectively legislation, because that's what CMA will be doing, it will be legislating, to be done without your having a direct input into it. There's a sort of constitutional question which is the background which is there at the background quite a lot of some of the reforms that are being proposed. So I think there are questions for you as MPs about the extent to which you're happy for lawmaking to be done by a body, the CMA, which is neither elected nor even accountable really to you in the way that ministers are.
Who regulates the regulator?
Right? Who regulates the regulators is always a good question.
I'm going to have to be very brief with the rest of my questions and very brief with answers, otherwise I'll run out of time, but go ahead, Mr. Penrose.
Can I just back up what George was saying there? Because the risk with the new Digital Markets Unit is of regulatory creep, as he's just describing, of their mandate being gently but inexorably ratcheted up and expanded. You can see that's already happened over a period of decades where the same powers already exist and have done for a while in the economic regulators. And if you look at the amount of time and expense it now takes for them to take a price decision, it's thousands of times more expensive and slow compared to what it was 20, 30, 40 years ago. So the danger is that unless we have this new set of powers in the Digital Markets Unit very closely ring-fenced and with some very serious checks on what they're allowed to do when they extend their powers and how we whittle them back. There's some processes which are needed, which I've recommended in my report. If we don't have those in place, then you're going to end up with creep, and in 40 years' time, our successors, but two, are all going to be sitting there thinking, why on earth weren't they bright enough to put those things in place?
We don't want to dissuade people from being innovative or continuing to invest.
Exactly.
But Mr. Penrose, this work is taking place in the States at the moment, isn't it? So are we just so far behind what's being discussed and legislated in the States, do you think?
Do you mean the digital markets? Yeah. I think it's happening everywhere, but I don't think that we are massively behind necessarily. I think it's a developing area of competition thought. And in fact, we've done quite a lot of work in this country. We've brought across Jason Furman, for example, Professor Furman, who produced the Furman Report, and done quite a lot of work within the CMA since then as well. So there's no national premium on thought leadership, and I think there's an opportunity here for the UK perhaps to become one of the thought leaders, because if we can move faster, be a bit nimbler, get to the right decisions quicker than some of the other competition authorities which we've just been discussing and some of the other jurisdictions, then we might actually be able to set an example and lead the world's thinking in this area, providing we're quick and right.
Hopefully what we're trying to do with this inquiry. I just want to focus on the consumer's point of view, and I'll come to you first, Mr. Peretz. So in which sectors or markets in competition policy are failing consumers the most? Who's the weakest chain in the link here?
Oh. Be slightly careful about them, because any of them could walk through the door and be my clients.
Okay. Shall I pass to Mr. Penrose?
I mean, obviously, there's a lot of concern about the power of the big digital companies. There are, but there are. One can see problems in all sorts of areas. I mean, if you think of the areas that the Competition and Markets Authority has looked at recently, the energy sector is clearly. There was a very big, in-depth report, but it would be over-optimistic to say that solved all the competition problems in the energy sector that are going to come back in all sorts of different ways. There's a lot of unhappiness with competition in the water industry. And John, I think it's a political point, but for what it's worth, I agree with him that very much in the regulated sectors urged that the regulators be focused on trying to introduce competition where possible, and in obviously areas like telecoms and to some extent in airports, that has happened. In water, it's very difficult to do because of the infrastructure. So that's a sort of long-running problem. But yeah, I mean, competition problems can blow up in all sorts of, even areas as traditional as funerals, which is a market that's existed for centuries. You can have, there could be difficult problems partly linked there to problems of, which are sort of almost sort of consumer issues. The basic point that for obvious reasons people do not shop around very much when they're purchasing a funeral because people don't want to.
All key services or industries, Mr. Perrott, everything you've talked about is actually critical to how people
Absolutely.
conduct their lives.
Indeed.
So apart from funeral services, which is something I hadn't read up on immediately, Mr. Penrose, do you have anything else to add to what Mr. Perrott has said?
I'd just say that there's a couple of high-risk areas to look at. One is anything where there's a network monopoly. So that's most of the utilities which have already got economic regulators. Those economic regulators were set up because there's a network monopoly embedded in the core of them. The rest of the industry may be fine, but the network monopoly is where you end up with consumers being ripped off or being in danger of being ripped off because of the network monopoly powers. There's also a problem with any industry where there's information asymmetry, so where the seller knows an awful lot more about it than the buyer, because they can bury rip-offs in small print. That's most common in the financial services sector, historically. That's why we have the Financial Conduct Authority. But it's not exclusively confined to it. And the third area I'd mentioned is one that you've already been asking about, which is where there are new network monopolies being developed in the digital world in industries that didn't exist before. But that's just a modern example of the old-fashioned network monopoly problem sort of coming up in a different flavour.
You talked about a problem that we have right here, right now with new tech, but Mr. Penrose, I'm going to take you back all the way to 2008 and the recession. So the CMA stated the UK competition report found that since 2008 recession, levels of competition have still not fully recovered. And that's remarkable to think that from where we were then to where we are now. So what are the consequences of this for both businesses and the consumer, Mr. Penrose?
The consequences are that if you are an entrepreneur trying to launch a new plucky startup to bring the latest app or the latest new product to your potential customers, you're going to find it harder. It's going to be much more difficult because the chances are that somebody can gang up on you. One of the incumbents can gang up on you. And if you are a consumer, it means that therefore you won't have the benefits of those kinds of new products being brought to you, and that the companies who are currently selling you things are just a bit more fat and happy because they aren't having to pedal so hard to delight you every day because they're not so worried about losing your business. And it's as basic but as fundamental as that, I think.
So, Mr. Perrott, can you offer us any insight into what policies are required in order to restore the pre-recession levels of competition that Mr. Penrose just mentioned?
Well, I mean, there are obviously a range of views, and I'm sort of conscious I'm sort of talking, as it were, on behalf of the law professions and competition lawyers as a whole, so I don't sort of want to exceed my remit too much. I mean, I think a couple of, I hope, relatively uncontroversial points. I mean, one is, I suppose this is potentially, it probably is a little bit controversial, but I think given the context, but I think the point is uncontroversial enough. Trade barriers are a problem because if you make life difficult for people, for foreign companies to enter the market, that can insulate some British companies who could actually benefit with a bit of foreign competition. And one of the challenges of post-Brexit policy is obviously to try that there has, I'm sort of conscious that the views on Brexit differ, but I think it's objectively true that hardly capable of being denied that there's been a raising of barriers between the UK and the EU. That may be offset to some extent by reduction of barriers between the UK and other countries, but that's a very, the trade policy and competition policy do interrelate, and the more trade you have, the more competition you have. Indeed, one of the reasons economists say that trade is good is because it generates more competition. It's the foundation of a lot of the models that predict greater economic growth if you have lower trade barriers. So that's one thing you can do. Obviously, you've got to look at, as John did, at competition enforcement to make sure that it's fast, that it's sufficiently deterrent, but also, on the other hand, doesn't prevent businesses doing things that they should be doing, which are pro-competitive, because they're worried that they will be found to be doing something that's anti-competitive. So getting that balance right is important.
Thank you, and thank you for being so frank, Mr. Perrott. I always think it's best to ask the lawyers where the loopholes are. And my final question to you, Mr. Penrose. In the State of the UK Competition Report, published back in 2020, the CMA noted that there are significant differences in who experiences worse outcomes from markets, such as those from low-income households and the elderly. So how can we ensure that we are counteracting some of these differences? And I want to talk about real-world markets and also then online markets, because I think there is a huge issue about people having access to information, the confidence to make choices, even having the ability to choose as well.
And I think those last 2 points are absolutely central. So it doesn't matter if you are online or in the analogue world, having trust in the legitimacy and the accuracy about what you're being told about the product or service you're buying, knowing that it's going to have to be true, and if it's not, that you've got some sort of consumer redress. You can take it to a small claims court, you can take it to an ombudsman. There's a cheap, cheerful but effective way of getting fast, replacement of the faulty part or whatever it might be. Knowing all of that stuff is not only essential for consumers, it's also actually essential for our economy, because it means that the economy just works faster. If you don't have to, with all due respect to the legal profession, you don't have to reach for your lawyer when you're buying a slice of toast, because it's just you've got a more efficient way of solving any problems that might arise. That's a much better way to run a country. It's a much better way to run a society. It's a much better way to run an economy, and it makes us more productive. So you want to have that. And the danger, I think, particularly for the online world, is that while for reputable firms there's plenty of those kinds of consumer redress available, and if something goes wrong and you bought it from a reputable supplier on Amazon, you can kind of get your money back or get a replacement. There's an awful lot of scams out there. There's an awful lot of things which aren't reliable, and there is just a lower degree of trust, and I think rightly at the moment, that everything you read online is going to be correct, because it flipping well isn't some of the time. And so that's the danger, that the trust and the legitimacy of the system, and therefore the belief that you can get consumer redress when you need it, when something's gone wrong. All of that needs to be upgraded in the online world, so it matches what we've grown over decades to expect in the traditional analogue world as well.
I just want to clarify. So we've spoken a lot this morning about how effective competition and competition policy will benefit consumers and the economy. We've talked a little bit about consumer rights legislation. But I just want to unpack that a bit between effective enforcement of the legislation and the rules that we've inherited from the European Union. We've inherited a lot of consumer rights legislation from the EU on goods, on services, on digital content and digital services. Are both of you saying that actually the kind of regulatory framework for consumer rights and protections is broadly okay, it's just an enforcement of those rights that's the issue? Or do you think if we do get a piece of primary legislation, we need to look at consumer rights as well as competition policy and enforcement? John?
So my report is quite explicit, saying that the consumer powers, which part of the consumer rights stuff, for the CMA needs to be upgraded. So I think it is definitely both of those issues that you've just been raising that need to be improved. But also, in the digital world, some of the ways that we enforce things like small claims courts and alternative redress systems, quite a lot of the time nowadays, if you want to get something replaced online, I can do that at 3 a.m. via an app with a reputable company. If, though, I'm dealing with somebody who requires a bit more pressure in order to do the right thing for me, and I have to go to an ombudsman, to an alternative redress, to a small claims court, wouldn't it be great if they were as digital too, and I could do them at 3 a.m. 24/7 if I needed to? People are starting to expect that in all other areas of their life, and what worries me is that some of the basic bits of consumer redress need to be upgraded to take care of that and to keep pace with what people are expecting elsewhere.
Okay, George Perrott, anything on that?
Yes, I agree with a lot of that. I'm not a consumer lawyer, and the Joint Working Party is composed competition lawyers, but not consumer lawyers. But I think broadly, as it happens, most of us thought that the suggestions in the BEIS consultation paper and a lot of what John was saying about consumer law, for what it's worth, are important and right. I mean, there are really two aspects to this. One is, at the individual level, it's the service that dispute resolution mechanisms, which can either be the state's one, the courts, or dispute resolution mechanisms set up by trade bodies, are those offering consumers an adequate service. I think there's a lot to be said that they aren't. As it happens, I have personally tried to use the small claims court during the pandemic to get some airline ticket refunds. I mean, obviously, as a lawyer, I was pretty comfortable using the process, but there was a certain amount, you had to pay a certain, proportionately quite a lot of money to start the process off, which was a bit of a disincentive. And you had to be prepared to, set out your case, which is something that obviously I found easy, but other people might find more tricky. And the process took an awful long time before it got anywhere, which is the real problem. So I read what, simply as it were a user, what John said about the small claims procedure with a certain amount of sympathy. And there's also obviously a lot that industries can do to have informal mechanisms that they set up of their own. The other aspect is looking at systemic issues. If companies are systematically behaving badly to consumers, what could be done? And I think there's pretty much a consensus that the CMA's powers, which are aimed to deal in a systemic way with customers whose business model is about exploiting consumers, those powers need substantially beefing up. I used to work at the OF. I was a lawyer at the OFT back in the 1990s with some extremely antique powers that just took ages. And essentially, when you got there, it was a sort of don't do that again order, which was then quite difficult to enforce. I don't think things have improved a bit, but not that much. And I think there's a lot to be said for beefing the powers up further.
John, you talked about the kind of front door for consumers. I mean, if they're not going to the small claims court and they're not in a regulated sector where there's a complaint system that's approved by the regulator and an ombudsman, if that's exhausted, people may have heard of trading standards, but they don't really know to go there. For individuals that are pursuing their individual complaints as opposed to the collective systemic actions, you put forward some recommendations to improve that for people.
Yes, I did. And just in parenthesis on the way past, there are plenty of examples of really good ombudsman schemes which are outside regulated sectors as well. So good ombudsman schemes can apply right the way across the rest of the economy, and they should, I think, as well. But you're right. Things like trading standards probably need quite a serious upgrade. At the moment, there are some good examples of trading standards schemes, trading standards offices around the country, but there are also examples of where the service has been quite hollowed out, depending on how enlightened your local council is, really. So in some cases, it's still fairly strong and has got real teeth and claws, and it does a decent job for local consumers. In other places, it's a bit of a paper tiger. So what I'm suggesting in here is that we create a new statutory duty as a minimum service level, if you like, for trading standards, so that if all else fails and push comes to shove, then you have got a sort of local trading standards office that is up to the task if needed. But I think it's important that it is local, because one of the other things that we've got an issue with is that for small-scale, local anti-competitive behaviour, if all the estate agents in a particular area decide to gang up together, or all the local hotels do, or whatever it might be, quite a lot of those things will be too small for the CMA to take very much notice of. It won't move the dial on their radar. And you do need to have something that does proper local enforcement if necessary. So for both those two reasons, you need to have a more even and on average higher quality trading standards offices around the country, even though some of them are already good.
Thank you. Richard Fuller, please.
Thank you, Joe. Mr. Peretz, you mentioned some of the challenges for the CMA, or new challenges, so resources for their current work, new additional responsibilities, defining what the competition rules may be post-Brexit. And I think Mr. Penrose talked about 2 decades. It's the last significant piece of legislation to give some direction. We've talked about some of the pressures with digital coming up to the same standards as analog sectors. Do you think we're asking too much of the CMA?
It's different. It's a very impressive organisation in many ways. It's got some very, very good people working for them. There are resource issues. it isn't quite right to say there's been no competition legislation since 1998. The Competition Act was 1998, but there was also the Enterprise Act in 2002 that made quite important reforms, although not on the prohibitions. And then there's the Enterprise Regulatory Reform Act of 2013 that actually created the CMA, because before then there was the Office of Fair Trading, and it sort of reformed the institutions, but also had some sort of procedural changes. So there has been competition reform since 1998, but the basic structure has been in place since then. So back to the question of whether the CMA is up to the job. I mean, I think it is. There's always questions about resources, but it's a body that has now been doing its job for a long time. It's worked out the sort of mix of expertise that it needs and how to operate the regime as effective as it can within existing constraints. We can talk about the reforms. Certainly I and the Joint Working Party would like to see to make things faster and more effective. But within the current legal regime, I think CMA does pretty well.
I'll go to Ms. Penrose, but I may come back to you on this question. Ms. Penrose, for many who supported leave in the referendum, anticipated that there would be a regulatory reforming zeal post departure of the European Union, but we note that the search for a chair of the Competition Market Authorities commenced nearly a year ago. In fact, I think, Chair, we were supposed to do pre-hearings in June of this year. We still don't have a chair, and it's rumoured that, I think someone stated that the current CEO may not seek another term when he steps down in July of next year. Where's the oomph?
A very fair question, and I think to your earlier question, are CMA up to it? Yes, they are, but they need some oomph, and they need to upgrade themselves as well. And we can't afford to let them not do that because of all these extra responsibilities post Brexit and post pandemic, which we need them to take. And I'm not critical of the individuals within CMA, who are very impressive indeed. But I'd be a little bit less sanguine, I think, than George was just now about how CMA and CAT in particular work, because if you talk to the people who use the system, not the people who operate it, not the people inside the organisations or the lawyers who appear in front of them, but if you talk to the businessmen and women and the investors who need fast, certain decisions in order to make business decisions, what they say is, look, the processes of getting to a decision too often within Britain's competition decision-making bodies is just too slow in the digital world, and it's getting left behind by the digital world, which is moving faster and faster and faster. And what business people and investors need is, for most decisions, apart from the really, really complicated ones, they want certainty within weeks or months, not years. And that's not happening at the moment. Now, as I said, that's not a criticism of the individuals within the system, but it does just illustrate how much of an upgrade we need.
So when you say what's the solution then? I mean,
well, I've made a series of recommendations about specific changes, but the broadest one is, in management consultant speak, is a core process redesign. Is basically you need to have probably chaired by a retired judge who is used to boiling cases down to their fundamental essentials and saying, there's 101 different issues here, but actually there's only 4 that are going to make the difference and decide this case. So ignore the other 97. We're going to focus on those 4. They need to do that from day one of an inquiry and get to the point, get to what lawyers I've spoken to call the killing ground really fast. Ignore all the other stuff and say that's interesting but not relevant, and therefore get to an answer much more quickly. It's perfectly doable, I think, and there's a lot of goodwill for it, but you need to get them to work out the details.
So I'm clear. Now, when you say core process reform, were you referring to how they look at individual cases? Was that core process reform about how CMA does its job overall?
So it's I think in this case, I think the answer to that is both. It's how CMA and CAT between them, for a complete case that starts in CMA and ends up at CAT, how can they get through that process really fast without any diminution in the quality of the justice, but how can they get to the right answer much, much faster and also much more cheaply as a result?
Yeah. I mean, John has exactly sets out the challenge, just to get the sort of pipeline between the start of an investigation or the lodging of a complaint and the sort of end result, and try and make that pipe as short as possible. One reform which John touches on, but which the JWP has backed for some time, is it's trying to get rid of, at the moment, what is a major roadblock in the process, which is in Competition Act cases, which is the process of writing an enormous decision. Because what we did when we set up the regime in 1998 was effectively we took the EU administrative law model, where everything is centred on the Commission as the main decision taker, and there's a lot of EU law about procedural safeguards in front of the Commission, because the Commission is at the heart of the EU regime, with a certain amount of fairly light supervision from the European courts. So we took that regime with sort of which involved the immense burden of writing an enormous decision which deals with all points that have been made by all the affected parties. And then we put on top of that a whole English trial litigation system which involves, and inevitably involves in the English system, where courts, when they deal with factual questions, expect witnesses and expect a certain amount of cross-examination, and expect, if there's conflicts of expert evidence, to have the experts in the court and dealing with. That's just how the English procedure works, not how the general court works, because it's a different model. But in any English system, or Scottish system, remember I'm representing Scottish law services as well, you have the process of a trial of some sense. It doesn't really help. One of the things that Cage has suggested is moving from a merits review to a judicial review model. That doesn't really help with the sort of thing you're looking at. When you're in the game of imposing very, very large fines on companies, you are in effectively a penal context. And when you get into that context, even a judicial review is going to involve a pretty intensive scrutiny and quite a lot of time. So the problem we've got is we've got this immense process leading up to a decision, then you plonk on top a whole elaborate process of litigation and a trial. So you've got both. It's a sort of monster that's been put together, two different sort of animals, sewn up rather inelegantly. What do you do about it? Because that's the pipeline.
What's the Peretz?
What's the solution? Well, you won't really be able to deal with the English trial bit, because in the end, if you're imposing huge fines on companies, they want their day in court, and the legitimacy of their regime depends on having their day in court. What you can do is try and get rid of the doorstop of the decision. I mean, you get the CMA decisions now run to sort of 1,500 pages with huge annexes dealing not with technical points, but the whole essential parts of the case. I mean, they're writing. I was tempted to compare it to Tolstoy writing War and Peace, but Tolstoy, when he was writing War and Peace, didn't have to check case law and make sure that he was answering every single point put to him by the parties. And so it's a huge effort, which is largely wasted, because if the decision is then appealed, the Competition Appeal Tribunal reaches a judgment, and everyone who then wants to look at what was decided just looks at the judgment. The decision sort of sits in the archives. You want to get rid of the decision. And that needs effectively moving to a more prosecutorial model. So what all the CMA needs to do is it says the first stage in the process at the moment is the CMA issues what's called a statement of objections, which is their preliminary theory of the case. And that's what we would say is that you stop there. The CMA presents its preliminary theory of the case. That, if you like, becomes the indictment. You then put the matter in front of the CAT. And courts, it's much easier for courts to manage the huge volume of stuff that gets thrown at at the authorities when you've got a Competition Act case. I mean, inevitably, if you're saying that a huge multinational company is going to be paying fines of hundreds of millions of pounds, they will throw the book. They will employ expensive lawyers. They me. They will get people like me to write immensely long submissions. What the CMA feels it has to do when writing a decision is it goes through every single word of those submissions and make sure that it answers them. No court ever does that. No court judgment, even in a hugely contested case involving billions, writes a judgment that is long on War and Peace, and if they tried, the Court of Appeal would have a screaming fit. What courts do is that they fill it. The judge will say, I'm not really interested in that aspect of the case, Mr. Peretz. Could you concentrate on this bit, please? They will manage the case, make it manageable, and it will be dealt with. And you can get the whole thing done much more quickly.
Very good. I think in the interest of time, John, Mr. Brennan, I'm going to jump to... I'm coming to you anyway, so you can add in,
That's not an uncontroversial solution, is all I would just put across the committee's bows.
Thank you. I want to just come to some of the regulated areas, Mr. Penrose. So in your report, you said, quote, outside the network monopolies with their regulated asset bases, there is no inherent reason why most of the rest of each of these sectors, meaning regulated sectors, shouldn't become a normally competitive industry with the same high standards, strong competition, and consumer power. So what were your, and then you had some suggestions. What suggestions do you have for how the competition can be better promoted in these regulated sectors? What would you like to see?
Yeah, and to be fair, there's a couple of sectors where this process has already begun and has worked quite well. The best is probably actually the airlines and airport sector, where, broadly speaking now, most of the airports, apart from the network monopoly, which is inherent in the hub at Heathrow and a little bit in Gatwick, most of the rest of that is largely competitive. All the other airports are pretty competitive, and they're deregulated to become, quote, normally competitive already. So it can be done. Similar sort of thing already underway in large chunks of Ofcom's telecoms responsibilities as well. So it can be done. There's a fairly straightforward process that you could apply, and which I'm suggesting that we should, which is to say, look, for each of these industries, you go to the sector regulator and you say, look, you're all starting from slightly different places. Water is much less competitive at the moment than telecoms. You're all beginning in different places. You all have slightly different legal powers. So come up with a tailored plan that says it's going to take us 2 years, 3 years, however long it is, to get as much of this market that isn't a network monopoly or something which is inherently difficult to make competitive. And here's the steps we're going to take to get all the rest of this industry to become competitive step by step. Here's the extra powers we're going to introduce. Here's the competition we're going to encourage. Here's the standardisation of interoperability, so that there are fewer competitive barriers. Here's what we're going to do, and at the end of that process, we're going to be able to hand back responsibility for this bit of telecoms or that bit of energy or this piece of water to the CMA. It won't, because it will be fully competitive, and it won't need upfront heavy-duty ex-ante regulation, which is some of the stuff we need to be worried about, because that's the thing that creates the burdens and slows down industries and makes them less competitive and puts consumers at risk if it isn't there. But once you've made it fully competitive, tell everybody in advance, publish the plan so everyone can invest on the back of it and make their plans together, and businesses can get everything lined up. And then at the end of it, the good news about that is it doesn't take primary legislation. All it takes is an adjustment, a letter, to the existing memorandum of understanding between whichever Ofwat or Ofcom or Ofgem or whoever it is, and the CMA, and they just adjust the memorandum of understanding, and it takes place immediately on that basis.
Thank you. That's very clear and a purposeful recommendation, Ms. Penrose. Just the base for that, my final question, if I can, what is the current process? I think we have 94 regulators. I picked off the website, not all of them economic, and 510 agencies that are listed on the government's website, not all of them economic. But from the purposes of competition, a number of agencies are out there that do affect competition. Where's the annual scorecard for their performance in the public domain? Where's the annual review along the lines Mr. Penrose was suggesting, Ms. Peretz, for whether they are engaging in scope creep or whether indeed they could be handing back? Where is the pro-competition assessment for those regulatory agencies? Where can I find that?
I can't really help you with that. I simply don't know if there is any such thing. I may be told that there is, but I'm not aware of it.
In your work as an expert in competition law, the role of regulators presumably has quite a significant effect on that.
Yes.
Don't you think it's odd that you don't have to hand the annual handbook of regulator performance that you can review and use that to assess the performance of competition policies in the UK?
Yeah, I mean, you've obviously got their annual reports, but although, of course, the annual reports are marking their own homework.
Yes, exactly.
But you can often get, there's quite a lot of objective information in those reports. You can see things like the number of cases handled and speed of cases and so on. But no, I mean, I'm certainly not aware of such a scorecard, because you've got to set up an agency or somebody who's got to do the work to generate the scorecard.
The RPC be expanded, do either of you think, to come with that, or is that different roles?
I think the RPC does really important work. It's probably slightly not quite what you're describing, but they are absolutely essential for driving better regulation and reducing regulatory burdens without cutting standards. So yes, they're sort of adjacent to what you're describing, and it's absolutely essential that we upgrade our better regulation processes within Westminster and Whitehall. That'll get us quite a long way to what you're describing, I think, but you'll still have a whole host of non-economic regulators who may be, who are doing important work for the right reasons, but they may not be taking enough account of the burdens they're creating, which is why a proper red tape regime, 1 in, 2 out and no exceptions, proper teeth and claws to it, is absolutely essential, and is one of the things I'm most worried about, because we've gone backwards in the last couple of years in that area compared to where we were before. And I don't want to minimise it. It's never easy. The whole purpose of Westminster and Whitehall is to create new rules, not to get rid of old ones, and that's a fundamental cultural issue. But therefore, it makes it difficult, but also essential, to have a better regulatory regime that genuinely works and stops that particular juggernaut from moving inexorably down the track.
Thank you.
I mean, there's always one problem with regulatory creep is it doesn't necessarily always manifest itself in actual visible changes in rules. It can manifest itself in, for example, and this is a real concern, I think, among a lot of business, information requests. And there's it's a routine complaint of, I think, every client I've ever had who's been involved in a merger inquiry, that the demands for information that come out of the COA are regarded as excessive. When I was at the OFT and then as a lawyer in the 1990s in merger control, for example, it never occurred to us to ask for disclosure of internal company documents. That was probably wrong for it not to occur to us. There's scope for some of that. But now it's the opposite extreme, and as soon as you get into a merger inquiry, you get this demand for huge disclosure of any conceivably relevant internal document, which is sort of akin to a major sort of litigation disclosure exercise. That's a huge burden of work. Sometimes it's helped by modern digital techniques, but sometimes the fact that you've got so much in the way of electronic documentation makes it more labour-intensive than sort of physically going through paper. So it's a huge exercise, and often completely unnecessary, because in the end, the answer to a merger question isn't really what the company might have thought it was doing, or some salesperson within the company might have thought with the consequences. It's an economic analysis. It's a sort of objective question. So I think there is a concern about that, and I think more routinely in Competition Act issues, there's just huge demands for information, and not necessarily even directed at the people who are actually the subject of the investigation, but often third parties who are sort of caught up in it find the whole process very burdensome. It's very difficult to track that. The only way of finding out is to listen to people like me, and it's all a bit anecdotal, but between us, we can see a trend to huge information demands.
Thank you for noting that statement. Then thank you, Chair.
Thank you. Mark Jenkinson, please.
Thanks, Chair. I just wanted to return to a couple of things that we've touched on. The first, Mr. Perrott, you mentioned the BEIS consultation on reforming competition. What's your assessment of those proposals? And could they be better enhanced to provide a better competition policy regime, or do they offer sufficient benefit to consumers, for example?
Well, there's a lot in those proposals, and as the Joint Working Party, we produced a response to them, which I'm sure the committee's got available. I can send a copy to them, and I'm simply won't have time to sort of go through everything we said there. I mean, if I can sort of try and concentrate on the main points. I mean, looking at the suite of competition powers that the CMA currently has, one of them is the Competition Act, which is essentially about, it's a sort of often described as an ex-post regime that's about picking up and conduct that is already in the rules, as it were, anti-competitive. It's things like cartels, it's things like excessive pricing by powerful companies. How do you improve that regime? I've already talked about our suggested move to a prosecutorial model, but which isn't obviously picked up or suggested by BEIS, but they offer suggestions, for example, a better mechanism for interim measures, because at the moment there is an interim measures power that the CMA has, which is to sort of act immediately in response to what seems to them to be, for example, a big dominant company behaving badly, but they hardly ever use it. And in fact, when I'm advising clients who are concerned that they're at the wrong end of practice like that, my advice to them is don't bother going to the CMA, just go straight to court, because you've got a directly effective right that you can cite in court and get an injunction. But that carries various risks and costs for the company, so it would be better for the CMA to be able to deal with things, particularly if it isn't a company that is at the wrong end of it and is prepared to put its hand in its pocket. But so we suggested effectively that the CMA perhaps should be given power to apply to the court itself in the way that a company could, and that would be quite a speedy, effective technique. I don't think the CMA is that keen on that idea, but that's a possibility. In relation to market investigations, this is the CMA's. This is a fairly unique feature and a very. I think it's a beneficial feature of the UK competition law regime, that it allows the competition authorities to look at a sector of the economy. It could be banks, it could be beer, it could be energy, it could be funerals, it could be all sorts of things, and look to see if there are adverse things that companies are doing in that area that are anti-competitive in a broad sense, not illegal in the sense of contrary to the Competition Act, but things that the practices that together that have the effect of stifling or limiting competition, and give them essentially a lawmaking power to deal with that. And those investigations have produced over the years very significant changes in the way industries are organised. I mean, the beer, that's a long time ago now, and it was in the previous regime, was an example. I mean, the whole system of beer ties with between brewers and landlords was put to an end by the predecessor of what are now market investigation powers. That has obviously huge effects on an industry that's extremely important to probably almost all of your constituents. So these powers are very significant, and at the moment the process takes quite a long time. Can you speed it up? I think there is a balance to be struck between. Some of the proposals that BEIS put forward would allow the CMA to take really quite dramatic action very early on, which we thought was really inappropriate, because you've got effectively it's a lawmaking power. And you may say it's fine for a body of bureaucrats to have a lawmaking power, but you've got to be very careful about what's the scope of that power and what are the processes you need to go through to exercise it. And you don't want to shortcut the processes, because otherwise you're going to get the law change is going to be wrong, and it's not going to command the consent of those who are affected by it. One of the strengths of the current system is that you have a fairly lengthy process, but it's a pretty in-depth review. There's lots of internal checks. So you've got a panel comes in, CMA does the first stage, a panel of people who are independent, sort of within the CMA but independent, come in and do the second phase. That businesses that go through that process in the end feel that the process is legitimate because they've been listened to, even if what they say hasn't actually been accepted at the end of the day. And that process when you're thinking about this as a lawmaking process, that fact that the process produces a result that most people who are involved in it feel is legitimate, even if they don't agree with it, is rather important. So there are dangers in shortcutting the process. The BEIS suggests reducing the role of the panel. In fact, the CMA isn't that keen on reducing the role of the panel, and we thought it wasn't right to reduce the role of the panel. But you've got to balance. If you want the detailed paper, I will send you the detailed paper. I'm sort of conscious that I've already been going on far too long, but there's a lot of detail in it. But broadly, we think there are a lot of things in there that are a good idea and would speed things up, but there are things we're not so enthusiastic about.
Thank you. Mr. Penrose, your view on the consultation?
I think it's an important and welcome step in the right direction. I don't think it'll take the trick completely. So there's a whole series of things that it doesn't yet cover and it needs to. So it doesn't, for example, deal with some of the things we've been talking about with the economic regulators and sorting them out. It doesn't necessarily deal with some things which are going to require primary legislation in due course. That we're going to need, as we said at the start, a new Competition Act, so there's some things there. But as a starting point to try and do the parts at least of the kind of core process redesign to solve some of the problems we were talking about earlier, yes, it's very, very welcome. It's not quite the full Monty, though. I mean, if you really wanted to do this, I think they're going to have to come back at some point and say, right, even when they've done all the things that they eventually conclude from this consultation, they're going to say, yes, but we're still not at the stage, are we, where we can come up with most decisions being weeks or months and creating certainty for investors and business people. And they're going to have to come back and stick a bunch of very senior lawyers and investors and business people and CMA and CAT people in a room with a big pot of coffee and a retired judge who's very used to running cases very efficiently and driving them demandingly. And we're going to have to lock the door and wait until they've solved those remaining problems and the smoke coming out of the top of the Sistine Chapel goes white. So I think it's a useful first step, but I think they're going to have to do more.
I just want to move to your Power to the People report, which we've touched on a couple of times. It was noted by the former CMA chair that distrust of markets can cause major challenges for competition policy, and you also note that trust and confidence in the legal and complaints system is important for consumers. How best can we foster and increase this trust?
So we've covered a little bit of that in some of the earlier things we've been talking about. I won't repeat them now, but some of the points we've been making earlier about better redress, both for ombudsmen and alternative redress systems and a stronger trading standards bodies and those sort of things, those really matter. And I think upgrading the consumer powers of the CMA and so forth, that will all help. So I won't repeat that now. There are, however, a couple of other bits and pieces where the world is moving on, the digital economy is developing, and where we need to be really alive to and trying to look upwind to try and find where the problems are occurring. I mentioned earlier on that there's a problem where there's information asymmetry, so where sellers know more than buyers and they can hide rip-offs in the small print. That's one crucial area which will, if left unchecked, could easily multiply across the digital economy. For example, every time any of us sign up for Wi-Fi in a local hotel or on a train or at a sports event, there are pages and pages and pages of terms and conditions which none of us ever read, and which could involve, to give you a horrifying example, somebody ran a test, thankfully a harmless one, online, where buried in the terms and conditions was the pledge to hand over your firstborn, and 98% of people signed it. So there's a real problem with that, and it's going to get bigger because of online rather than smaller. There's also now there are things you can do to sort that out. You can do things with minimum legal standards for contracts, saying some things aren't allowed. That already exists to an extent. There's unfair contract terms and things like that. But you're probably going to need to upgrade that. You can probably do things as well with fairness tests, and there's some suggestions in here about how we can come up with a sort of rule of thumb for business people so that they don't have to reach for brilliant and expensive lawyers like George every time, that they can work it out so they're broadly speaking going to be right most of the time just by applying a sort of decision rule in their heads. You can also do things with some of the online decision helpers, so things like Auto Sergey and the like, so and the price comparison sites. You can see a world where given a bit of artificial intelligence and so forth, in a few years' time, you might be able to get them to take some quite complicated bits of advice and provide consumers with high quality advice, which will level the playing field and make it harder for sellers to bury rip-offs in the small print. So there's that. There's also sludge, where we need to just... sludge is, if you're familiar with nudge theory, about trying to persuade people to do things, sludge is nudging for evil. It's trying to persuade you to do the wrong things for yourself. And in a very, very junior level, and this is not an example of evil, but yeah, if you've ever tried to sign up to something like Amazon Prime and then unsign from Amazon Prime, it's a heck of a lot harder to get out of it than it was to get in. So that's not a very evil example of sludge, but you can see how that can get further. So we need to have ways of measuring sludge and saying, at some point it becomes genuinely a major problem for consumers and erodes trust as well. So all of those things, I think, are things where we need to upgrade our understanding. We need to get clever people at the CMA and elsewhere, and perhaps on this committee, to say we're going to need to have some new ways of dealing with old problems that have fresh legs in the digital economy. So none of these are new in principle, but all of them are new in the way they're being applied in the digital economy. And we're going to have ways of thinking about how to cope with them, so that consumers know they can trust the online world in the same way as they can trust the offline world. At the moment, that's not there.
I was going to ask for some... Sorry, go.
I mean, John's example, which is his paper of the contract to hand over the firstborn. As far as I'm aware, none of my clients have a contract which says that. So I think I can say fairly that without too much concern that would not be enforceable under all the Unfair Contract Terms Act and Unfair Contract Terms Directive and regulations. I mean, the CMA, or so the OFT, has done quite a lot of useful work under the Unfair Contract Terms and Consumer Contracts regulations of going round businesses and picking up some of the most horrendous contracts that, I mean, not quite handing over the firstborn, but quite horrendous terms.
It is the case that these terms and conditions, the unfair terms, end up in contracts in the full knowledge that they are unfair.
Well, certainly any business that writes long terms and conditions ought to be aware. Of course, sometimes they're not, or the person writing them isn't. But certainly any lawyer who drafts them should be aware that you can put anything in your contract, and as John obviously right, we've all had experience that we sign things that we haven't read, and even as a lawyer, I frequently sign things that I haven't read. You just don't have time to do anything else. There's if somebody who is drafting those, if they're doing their job properly, ought to be very conscious that there are limits in what you can put in them. Set out in law, the Unfair Contract Terms Act, the Unfair Contract Terms and Consumer Contracts regulations. But life being what it is, people don't always get the law right, and of course a lot of consumers have no idea so they think, if it's in the contract, it must be binding. One of the things I would say, I'm not a consumer lawyer, but it always irritates me. You go into shops and you see a sign saying no refunds, no exchanges, and you can't put that up. I mean, and it annoys me because either it shows that yes, we know what the law is, but we don't care, or it shows we can't. Just complete ignorance of the law, which frankly nobody who's selling anything should be quite that ignorant of the law, right? And it also, of course, relies on consumers, not themselves saying that notice, that's not right, is it? Because most people aren't really. So there's a role for education as well. And the CMA has tried over the years to look at that as well.
Lost count of the number of arguments I've had over cash refunds for faulty goods.
Yeah.
So I think I had a question on the Competition Act, but I think we've touched on that quite considerably. So just one final question from me to Mr. Penrose. You chose not to take forward some of the recommendations from Lord Tyrrell's 2019 letter to the Secretary of State, such as proposals for greater liability on individuals and boards for of limited liability companies for competition law breaches. What was the reasoning behind not taking those forward?
I mean, I spoke quite extensively to Lord Tyrrell while I was writing this, along with a whole series of other experts while I was writing the report. The reason why I sort of cherry-picked it a little bit was because there are, I think, a series of what I will call straightforward, no regrets things, which everybody agrees should be done. And those are the ones which I specifically recommended in the report. I won't summarise them again here, but you can see them very quickly. And then the remainder, and Andrew Tyree's letter is 20-something pages long. It's pretty dense. There's an awful lot of stuff in it. So the remainder, quite a lot of them would be swept up into my recommendation for the core process redesign, saying because you have to take some of them and say, well, if I change this piece of the process, actually it'll reduce some other piece of legal protection, and therefore you need to change that bit too. So there's a whole series of interrelated ones, and which, frankly, you need to be a legal procedural expert to know that you're striking the right balance. And some of them, are to do with, as George was saying earlier on, about making CMA work faster, but they would create real concerns in other quarters that what that might translate as would be reducing the checks and balances on CMA's use of its powers. And so some of them had were quite controversial as well. So I sort of wrapped a collection of them together in the core process redesign, saying you've got to take all of these as a group because they all have trade-offs between each other, and there's some very important principles of justice which, if you strike the right balance in them by doing one and not the other, you might accidentally cause real harm.
Thanks, Chair. Thank you.
Just a final few questions from me before we wrap up. We've talked a little about the number of jobs the CMA has to do, and you often get into this discussion about when something is too big versus how many smaller things you need to do the job. Does the CMA need to be split up?
I suppose that raises the question of where you would split it. I mean, the split that's usually suggested is between competition and consumer policy. But I think, over a long, I'd say I used to work for the OFT, and I saw, it was a long time ago, but it certainly struck me then that there was a lot to be said for keeping both roles within the same body. I mean, there is a tendency, I think, for competition regulators to get a bit abstracted by fascinating economic theories and abstruse arguments, and it gets a little bit detached from the real world. And I think one advantage of it having a consumer arm is that it pulls the competition part of the operation into looking at the sorts of competition issues that really affect consumers. It helps, I think, with the prioritisation. And there are also a lot of areas where there is an overlap between consumer policy and competition policy. I mean, most obviously, if you're thinking about bad behaviour by very big companies, you can often look at that both as a competition, through a competition lens, it's an abuse of their dominant position. You can also look at it through a consumer lens and say, actually, what they're doing is things that are contrary to consumer law or data protection law, particularly in digital markets, or other areas. And it's when you're trying to problem solve, it's useful to be able to look at all aspects of it and decide which tools you are going to use. And there's always a problem with, if you have just a regulator that is just a competition regulator, everything it looks at becomes a competition problem. It's the old phenomenon, if all you have is a hammer, every problem becomes a nail. And if it has a bit of a wider suite of perspectives and remedies, you're more likely to tailor the solution to what is, the tool to what is actually the right one to deal with the particular problem you've got in front of you.
You agree?
Yes, the simple answer to your question is no, it shouldn't be split. Partly, as George was rightly pointing out, competition and consumer law or competition and consumer policy must go together. The whole point of competition is for the benefit of consumers. And I was always taught in business that structure and form should follow function. In other words, the things you need to do to fix CMA and CATR, this core process redesign I was talking about, do that and most of it will work. And at the end of it, at that point, once you've got a redesigned organisation doing a redesign process, if you then decide you want to make some organisational changes within it, that's the point you do it. You don't start off by doing the organisational changes first before you've even worked out how you want to do the job.
And presumably, therefore, you agree with the approach being taken on the Digital Markets Unit and the Digital Cooperation between Regulators Forum, where all the regulators are coming together to talk about digital issues without the idea that there should be a new digital regulator.
Yes, for a couple of reasons. One is that because the entire economy is digitising, if you have a digital regulator, pretty soon it hollows out the CMA and becomes the new CMA, and that's just a silliness. But also because we don't know what the new digital market's going to look like in the end, the new digital economy. We're partway through that process, but we've still got an awfully long way to run. Who knows what it will look like in the end? Again, focus on doing what you're trying to do, and then the structure of the institution will fall out at the end of that process once you've got the rest of it right.
And George Peretz, I noticed, I think it was last week, the CMA levied a pretty hefty fine on Facebook for basically not doing what the CMA asked it to do. When we talk about digital markets, we're talking about multinational companies, often based in the United States. Do we really have the power and influence here through what we're trying to do to have an impact on these companies, or do we need some new powers?
Well, that's the context of that fine is really interesting. It's an interesting merger case. It's interesting. It's Facebook's attempt to buy Jiffy, which is a supplier of GIFs, those sort of pictures that you get on your quite often on Twitter or something. Someone puts a GIF of a short bit of movement of. And the CMA has in fact gone slightly out on a limb internationally. Obviously, this is a major international merger, but the CMA picked it up and said, we see a problem here where other entities haven't. The way our jurisdictional rules currently work means that they found it was within their jurisdiction, and they've gone, as I say, gone somewhat out on a limb. I mean, Facebook is evidently, I'm not involved in the case, so I can comment to this effect, is plainly very angry. I think, to use a non-technical term, what has happened, you get the flavour of that from its successive appeals to the Competition Appeal Tribunal about what's being done to it. The fine arose out of what's called effectively an interim remedy. The Facebook had bought Jiffy before the CMA intervened. And what the CMA does in those cases is impose hold separate orders. Those have become it's one of those areas over the years that have become more and more onerous for the companies concerned. It used to be fairly light touch. It's now extremely interventionist. So frequent reporting obligations, demands to provide information about separation. Facebook clearly felt that this was completely unacceptable, that the CMA was demanding all this information, no doubt large parts of it coming from the United States. And it looks from the decision as if it's stonewalled to some extent. That's, of course, just hearing what the CMA says about it. And then got a very huge fine, huge largely because if you're going to penalise a company the size of Facebook, you really do have to fine it a large amount of money, otherwise it just doesn't notice. So it's a sort of interesting context. I mean, the CMA does seem to have a certain amount of courage. It's in its mergers jurisdiction. It's prepared to tackle problems that nobody else seems to pick up. There are, though, limits and dangers with that. And I think there will be cases where the CMA will need to ask itself, well, do we really want to be the only competition authority taking this point against some of these enormous companies that in many ways are comparable to countries themselves in their size of power. And I think it'd be interesting to see how that develops. I mean, so far it seems to have a certain amount of courage, but the problem with courage is it can turn into foolhardiness. We'll have to wait and see.
International collaboration is therefore an interesting point between the European Commission, the FTC and others for us. We've touched a little bit on oversight of the CMA and its interventionist approach in some measures, quasi-legislative approach in others. Clearly there's a conversation for us to have on the committee corridor here in Parliament about how we have proper oversight of regulators, but I'm just interested in if either of you have any specific views about how we ought to be doing that.
Can I go? I have there are a couple of recommendations in my report specifically about the upfront powers, the ex-ante powers, which we're about to give to the new Digital Markets Unit in the CMA. And there, what I've suggested is, firstly, those expanded powers will have to require primary legislation. They will anyway. So we'll get a chance to say, are we happy with those as MPs at the time? But once we've given those powers to the CMA, then I think they need to be framed in a couple of very important ways. One is that they should be last resort powers, so they are only to be used if they can't get to the right answer using their normal competition powers. And the danger of the upfront stuff is it's quicker, it's easier, it's quite a heady drug for any regulator to have in their medicine cabinet. So they need to be the last resort power, that they need to be subject to the better regulation rules that I was talking about that need to be upgraded, and that should apply to both the economic regulators and to this new unit in CMA, so that they come back regularly to look at the size and scope and the burdens that they're imposing. And equally, that every time there's a new digital monopoly that appears, and there will be new ones that appear as the digital economy develops, in an industry and with a company that hasn't been invented yet and none of us have ever heard of, we're going to need to add those new digital monopolies to the scope of the Digital Markets Unit in order to allow those powers to be applied. That shouldn't just happen on the say-so of the Digital Markets Unit or of the CMA. That should come to Parliament, I'm arguing, perhaps a secondary legislation, some sort of process, where we'll get a chance to say, hang on a second, is this really necessary? I'm also suggesting that when something stops being a monopoly, and they need to have the legal duty to try and erode monopoly powers so that things stop being monopolies over time rather than just becoming frozen forever. But when something does stop being a monopoly, they should have the power to abolish, to take them out of scope. And they shouldn't need to come to Parliament for that. If they're basically saying we don't need that power for this monopoly in this company anymore, they should just be able to write that off. But they should write a letter and make it clear in public that that's what they've done. All of those are essential bits of mechanisms to stop Henry VIII clauses and all those other things to make sure that we don't get regulatory creep and ever expanding regulatory burdens.
And any role for the House of Lords? You talked about MPs and the House of Commons there.
Sorry, the primary legislation point will clearly have to go through both Houses of Parliament, and if we had a secondary legislation process for expanding or reducing scope, that would be the normal secondary legislation process I would envisage.
If we were using primary or secondary legislation, you don't think there needs to be, for example, a joint committee that looks at these issues?
That's well beyond my pay grade, and I'd leave that to the parliamentary procedural experts to decide. Very
good. And my last question for you, John Penrose, is you were asked by the Prime Minister to do this report. We've talked about legislation. Have you been given any commitments about when we might expect some legislation?
No precise dates, and I think it'd probably be Les Majestés or something like that to reveal the contents of any future Queen's speech. However, I think it's pretty clear to any sort of independent observer that they can go quite a long way, and they clearly are trying to do so with things like the consultation, which we've talked about already, without necessarily needing primary legislation. But you're going to have some, because otherwise the Digital Markets Unit won't have the legal powers that it's going to need. So there's going to have to be a Competition Act. My guess is it'll be in the next session. No one will give anybody a firm date at the moment, and we won't know until Her Majesty turns up and does the speech. But it's pretty clear that's going to happen one way or another, and it can't be avoided.
Okay. Well, that will bring this initial session to an end. So George Perrott, John Penrose, thank you for your time and your evidence today. Thank you always to colleagues and clerks. Bring the session to an end. Now, order.